As has been stated, one of the most contested issues in this appeal is whether the basic structure doctrine is applicable in Kenya. I shall therefore endeavor to address this issue before delving into the other issues raised in the consolidated appeals. The appellants and the respondents in support of the appeal came out strongly, challenging the High Court's finding on the applicability of the doctrine of the basic structure in Kenya. On the other hand, the respondents opposed to the appeal came out in equal measure in support of the findings of the High Court. Both sides of the divide relied on scholarly writings, decided cases in Kenya and elsewhere, as well as the history, text, and context of the 2010 Constitution. It is noteworthy to point out that the scholars themselves were not in agreement on the applicability of the doctrine. Professor Migai Akech and Professor Charles Manga Fombard supported the notion of non-applicability of the basic structure doctrine in Kenya, whilst Dr. Ojwang, Dr. Linda Musumba, and Dr. Osogo supported the notion of the applicability of the basic structure doctrine. Be that as it may, the respondents opposing the appeal expressed fear that if the legislator is left unchecked, the 2010 Constitution may be dismembered and mutilated to the extent of it being a shell of a constitution. No doubt, the respondents' deep-rooted fear is informed by the history of lack of constitutionalism in Kenya. It is for this reason that the respondents opposed to the appeal urged us to find that the basic structure doctrine is rooted in Kenya's history, text, and experience, as well as comparative constitutional theory in the form of decided cases and scholarly works. It was their argument that the courts must reconcile contradictions, draftsmanship gaps, vagueness, and phraseology in the Constitution and arrive at the conclusion that the basic structure doctrine is applicable in Kenya for the safety of the 2010 Constitution. In support of their contention, they relied on several authorities which I have set out in my judgment, and in the interest of time, I shall not go through all of them. But the ones that I brought on board into my judgment include in the matter of the Speaker of the Senate and another, Mother Kerubo Moracha versus University of Nairobi, in the Commission for the Implementation of the Constitution versus the National Assembly, where Lenaola J, as he then was, held that where the basic structure or design and architecture of our Constitution are under threat, the court can genuinely intervene and protect the Constitution, end of quote. They also relied on the decision of Jasbir Singh Rai, and as I've said, they also relied on scholarly works, in particular the works of Professor Dietrich Conrad, writing on implied limitations. In support of the contention that the Constitution also has the unspoken language, they placed reliance on scholarly writings of Yaniv Rosnai in Unconstitutional Constitutional Amendments, the Limits of Amendment Powers, where he states, and I quote, "In order to find an amendable basic principles, one has to resort to interpretation of the Constitution as a coherent whole. It is, after all, a constitution and not just a disjointed collection of constitutional pieces which must be interpreted." According to this approach, the language of the Constitution is not merely the explicit one, but also the implicit one. The respondents opposed to the appeal argued that notwithstanding the fact that the 2010 Constitution does not expressly bar amendments, it does so implicitly as one has to pay attention to its overarching themes and/or the spirit of the Constitution. Heavy reliance was also placed on the Indian Supreme Court decision of Kesavananda, and in this Kesavananda decision, by a majority of 7-6, it was held that there are some provision in the Indian Constitution that form the basic structure of a constitution and hence are not amendable, not even when the prescribed procedures are adhered to. On the other hand, the appellants and the respondents in support of the appeal were clear. The basic structure doctrine is not applicable in Kenya. They urged us to find that the 2010 Constitution has sufficient safeguards that militate against hyper-amendments of yesteryears. The appellants and the respondents supporting the appeal also sought to rely on case law, decided cases, the history, text, and context of the 2010 Constitution. These included in the Council of Governors versus the Attorney General, where the Supreme Court stated as follows: courts may not impose a meaning that the text is not reasonably capable of bearing. In other words, interpretation should not be unduly strained. It should avoid excessive peering at the language to be interpreted, end of quote. On the invocation of the spirit of the Constitution, reliance was placed on a decision of South Africa in the decision of the Premier of KwaZulu-Natal versus the President of South Africa, where the Constitutional Court held that, and I quote, "The reliance upon the spirit of the Constitution is, in my view, misconceived. There is a procedure which is prescribed for amendments to the Constitution, and this procedure has to be followed. If that is properly done, the amendment is constitutionally unassailable," end of quote. Back home, the appellants and the respondents in support of the appeal also relied on the decision of Jasbir Singh Rai. They also cited the decision of the Speaker of the Senate and another, and also the decision of the Attorney General and another versus Randu Zai Rua, wherein these courts acknowledged that the people may amend the 2010 Constitution by a referendum to alter the territory of Kenya. That is to give effect to secession. They also cited the decision of the Senate and 48 others versus the Council of County Governors and 54 others. Then there is also the decision of Titus Alila and 2 others, where Fred Ochieng judge acknowledged the fact that our Constitution does indeed make provision for the amendment of the Constitution. In my view, the above decisions underscore the fact that the 2010 Constitution is amendable, subject to the process and methodology of amendment set out in Articles 255 to 257 of the Constitution being adhered to. As regards jurisprudence from foreign lands, decisions from Malaysia, from Singapore, there were also decisions from Uganda, from Zambia and Tanzania, wherein the appellants and the respondents who were in support of the appeal relied on, and all these decisions rejected the notion of the basic structure doctrine. In particular, I wish to read some part of the decision in the matter of Paul K. Semogerere and others versus the AG. This is a decision from Uganda, wherein they discounted the Kesavananda decision, and this is what they said. Those who frame the Constitution also know that new and unforeseen problems may emerge. That problems once considered important may lose their importance because priorities have changed. The solutions to problems once considered right and inevitable are shown to be wrong or to require considerable modification. that judicial interpretation may rob certain provisions of their intended effect, that public opinion may shift from one philosophy of government to another. The framers of the Constitution did not put any limitations on the amending power because the end of a Constitution is the safety, the greatness, and the well-being of the people. Changes in the Constitution serve these great ends and carry out the real purpose of the Constitution. There is also the other decision from Uganda, Male, Mabarizi, and others, which of course also discounted the doctrine of basic structure. So in my view, the above decisions from Malaysia, Singapore, Zambia, Uganda, and Tanzania demonstrate that the courts have rejected the doctrine of basic structure on the reasoning that a constitution, being a living document, must inevitably change as society progresses. That a living constitution must be flexible to allow for a country's growth, and the review of a constitution is essential so as to cater for new and unforeseen future problems, and hence it is inadvisable to have a constitution cast in stone. To my mind, I have no illusion whatsoever that the Kenya's constitutional past was indeed a dark past. The pre-2010 constitution was misused and abused for selfish political gains. Several instances stand out. In 1974, Paul Ngei, the then minister in the late President Kenyatta's government, was found guilty of an election offense, and by operations of the law was barred from running in the ensuing by-election. To save him, His Excellency, the late President Kenyatta, passed into law a bill tabled in Parliament and passed into law in a single afternoon, pardoning Honorable Paul Ngei of an election offense. Then there was the 1982 constitutional amendment that dealt a death blow to multi-party democracy and turned Kenya into a de jure single-party state of the then all-powerful Kenya African National Union. The reason for the hastily carried out amendments or dismemberments of the pre-2010 Constitution are not difficult to discern. The power to amend the Constitution was provided in Section 47 of the pre-2010 Constitution, and this power was reposed solely in Parliament to the exclusion of the proverbial Wanjiku. I have cited the provisions of Section 47 of the 2010 Constitution. Our pre-2010 Constitution, like the Indian Constitution, did not bar amendability. It is against the backdrop of the Indian Constitution, where there is no provision for amendment of the Constitution by the constituent power, but the power to amend being reposed solely in Parliament, that the Casavananda decision was made. In his scholarly writings, Yaniv Rosnai traces the history of the basic structure doctrine and how it was developed in response to Prime Minister Indira Gandhi's attempt to amend the Constitution. He states, "The Indian Constitution lacks any unamendable provisions. Also, Indian jurisprudence, rooted in British tradition, initially rejected the notion of implicit unamendability. That position, however, was revised in the 1960s and 1970s, following Prime Minister Indira Gandhi's far-reaching attempts to amend the Constitution, leading eventually to the judicial development of the basic structure doctrine. According to this doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic structure," end of quotes. Yaniv Rosnai provides a further criticism of the Casavananda case for failure to identify the unamendable clauses. He writes, "The Casavananda case did not provide a precise list of unamendable features that constituted the Constitution's basic structure, thus forming a sort of common law doctrine that develops on a case-by-case basis. And he further stated that the Kesavananda judgment created a constitutional quicksand. In his written submissions, Professor Charles Manga Foreman, an amicus curiae on the basic structure doctrine, outlines the essence of this, what he refers to as the much acclaimed Indian basic structure. And he states, the much acclaimed Indian basic structure doctrine owes its origin to the famous Supreme Court decision in Kesavananda decision, although the issue had been raised in a number of earlier cases. According to this doctrine, even in the absence of explicit limitation on constitutional amendment powers, Parliament's amendment powers are not unlimited. There are, as a result, implied constitutional limitations that render an amendment unconstitutional if it infringes, negates, or substitutes the basic structure of the Constitution, regardless of whether all the formal or procedural requirements of amendment have been met. End of quote. Professor Foreman points out that when the doctrine of basic structure was developed, India was dealing with, and I quote, India's 20th century independence constitution of the 1950s, whereas African courts are now dealing with made-in-Africa constitutions of the 21st century, end of quote. And that due to the changed circumstances, the Kesavananda decision is not relevant to our circumstances. This court has had occasion to express its reservations in adopting foreign concepts to our homegrown constitution. And I cite the case of Kenya Airports Authority versus Mitubel Welfare Society, where this court stated as follows: whereas citation and reliance on persuasive foreign jurisprudence is valuable, foreign experiences, values, and aspirations of other countries should rarely be invoked in interpreting the Kenyan Constitution. The progressive needs of the Kenyan Constitution are different from those of other countries. In my view, the position obtaining in India, insofar as it related to its constitution, was not any different from the position obtaining in Kenya before the promulgation of the 2010 Constitution on 27th of August 2010. The Indian Parliament has the exclusive power to amend the Constitution. Our Parliament has similar power to amend the Constitution prior to the 2010 Constitution. The situation obtaining in Kenya after the promulgation of the 2010 Constitution is different. There are explicit provisions on the amendments of the Constitution, as well as inbuilt mechanisms which limit Parliament in amending the Constitution. The methodology to amend the entrenched provisions is also clearly spelled out. There are also clearly spelled out entrenched provisions. Suffice to state that the Constitution itself anticipated that it can be amended, and it provided for its own amendment procedures. In the same Constitution, there are strictures as regard entrenched provisions which require a referendum and which ones do not. These are listed in Article 255, 1, Subarticle A to J, and I shall not go through them. The High Court, in the impugned judgment, appreciated as much, and at part of paragraph 473 of its judgment, it stated, to be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable. However, the scheme of the Constitution, coupled with its history, structure, and nature, creates an ineluctable and unmistakable conclusion that the power to amend the Constitution is substantively limited. The structure and history of this Constitution makes it plain that it was the desire of Kenyans to barricade it against destruction by political and other elites. As has been said before, the Kenyan Constitution was one in which the Kenyans bequeathed themselves in spite of and at times against the political and other elites. Kenyans therefore were keen to ensure that their bequests to themselves would not be abrogated through either incompatible interpretation, technical subterfuge, or by the power of amendment unleashed by stealth, end of quote. In my view, whereas the High Court correctly found that there are no explicit provisions in the 2010 Constitution barring amendments, the judges erred in finding that the bar to amendment is implicit. As stated above, the pre-2010 Constitution did not have provision for the amendment of the Constitution by way of a popular initiative, and neither did Parliament recognize the notion of implicit unamendability. Indeed, the issue in Joya and others versus the Attorney General was whether the Parliament could, in the exercise of its amendment power under Section 47 of the Constitution, repeal the Constitution. I have cited a passage from that decision of Joya decision that is relevant to this judgment. It is the Joya decision that paved the way for the amendment of the pre-2010 Constitution by constituent power via a referendum. This was in recognition of the supremacy of the sovereignty of the people, who then exercised that sovereignty in the referendum that birthed the 2010 Constitution. In my view, the Joya decision was our Kesavananda moment, and to paraphrase Yaniv Rosnai, this may have been as a result of the late President Kenyatta's and the late President Moi's far-reaching attempts to amend the Constitution, and there was need to curb those excesses. As history will attest, the clamor for a new Constitution was long and arduous. But that notwithstanding, when the Kenyan people finally bequeathed themselves with a new Constitution, they ensured that it would be free from hyper-amendments. Indeed, the 2010 Constitution was informed by Kenya's dark past, and its citizenry were determined, never again shall we have a Constitution that can be amended at will. In the formulation of the 2010 Constitution, a conscious effort was made to ensure that we do not have hyper-amendments. This conclusion is supported by findings contained in the final report of the Constitution of Kenya Review Commission, CKRC, which mirror Chapter 16 of our Constitution. I've reproduced part of the reports of CKRC that mirror Chapter 16 of our Constitution. Following the recommendations of CKRC and true to word, Chapter 16 of the 2010 Constitution is dedicated to amendment of the Constitution. In my view, the clear text and language of Chapter 16 is that there are explicit provisions in the 2010 Constitution providing for amendment, and therefore there is no reason to look outside the Constitution and import the basic structure doctrine on the basis that the Constitution has the unspoken language and or implicit provisions. And it has now been slightly more than 10 years since the Constitution was promulgated, and to the credit of the drafters of the Constitution, the 21 attempts to amend the Constitution, 19 were through a parliamentary initiative, whilst 2 were through a popular initiative, have all fallen by the wayside. These 21 attempts are tabulated in the written submissions of Mr. Ogeto, the Solicitor General appearing for the Honorable Attorney General. I have also reproduced those 21 attempts in part of this, my judgment. It is also true that the framers of our Constitution balance between flexibility and rigidity. To this end, CKRC had recommended, and I quote, that there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too simple, it reduces public confidence in the Constitution. The converse, however, is also true. If the amendment procedure is too rigid, it may encourage revolutionary measures to bring about change instead of using the acceptable constitutional means. Thus, a balance must be struck between these two extremes, end of quotes. Accordingly, a balance had to be struck to avert violent revolutions against abusive amendments. In an article, The Politics of Constitutional Change in Kenya Since Independence, 1963 to 1969, Professor Okoth Ogendo underscores the fate of post-independence constitutions. He writes, constitutional systems in Anglophone Africa have not had a happy history, especially during the last decade. Almost without exception, the independence documents have either ended up in military dustbins or have undergone change so profound and rapid as to alter their value, content, and significance beyond recognizance. End of quote. I hear the good professor saying the Independence Constitution was so badly dismembered, and that if they did not suffer the fate of dismemberment, it was more likely that the Constitution would find their way into dustbins following military coups. The writings of Professor Okoth Ogendo echo the profound words of John F. Kennedy in 1962 when he stated, and I quote, "Those who make peaceful revolution impossible will make violent revolution inevitable." End of quote. It is no secret that the framers of our 2010 Constitution struck a balance between stability and instability by providing for amendments in Chapter 16 of the 2010 Constitution, and this being the supreme law of the land, it was desirable to give it a more stable character and free it from hyper-amendments. This is important as no society is static, and what is good for one generation may not necessarily be good for the next. In an article entitled "No Generation Has the Right to Impose Its Own Values and Political Principles on a Later Generation" by Professor Fatuma, he cites another scholar, Colvin De Silva, who states as follows: "Constitutions are made in terms of the stage of development at which any given society or country has arrived. In terms of that stage of development, it looks upon things, and for any generation of people to imagine that it can so completely project itself into infinity of the future, so as to be able to decide its own generation that it will constrain a future generation or generations forever within the confines of its own postulates, is to make a mistake of thinking that any human collectivity is the equivalent of the divinity." End of quote. He concludes, "It is unlikely that the framers of the new or revised African constitutions wanted to prevent future generations from repealing these constitutions. A constituent body is omnipotent only to the extent that it has no power to destroy or limit the omnipotence of a future constituent body. In short, the present and future generations should not be ruled by the dead hand of their ancestors." End of quote. I think it behooves us to recognize that in spite of the supremacy of constitutions, we cannot and should never legislate from the graves, what Professor Fatuma refers to as the dead hand. We cannot possibly shackle future generations but by what we consider to be noble today. The other troubling aspect of the impugned judgment is that the High Court came to the conclusion that whatever is amendable will be decided on a case-by-case basis. And this is what they said: whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, the history of the clause and the constitutional history, and other non-legal consideration permitted by our canon of constitutional interpretation principles." End of quote. The above finding, in my view, poses difficult questions. Who is to carry out the fact-intensive determination? And at what stage in the process of constitutional change? The appellants told us, and rightly so in my view, that in terms of seeking an advisory opinion, Wanjiku has no place, as by dint of Article 163, Sub-Article 6. This is a preserve of the national government, a state organ, or a county government. I reproduce therein the provision of that article. Since Wanjiko does not have the luxury of approaching the Supreme Court under Article 163, Sub-Article 6, how does Wanjiko get to have an issue subjected to fact-intensive determination? Sight should also not be lost that judges, being human, are not infallible, and they should not arrogate unto themselves the unfettered power to validate or invalidate amendments on the basis that they are eternal causes from their preferred reading of the Constitution. If for a moment we were to find that judges are fallible, where will be the unwritten constraint? The absence of constraint, no doubt, leads to uncertainty and absurdity. In an article by Adan Kasie Abebe entitled "The Substantive Validity of a Constitutional Amendment in South Africa," appearing in a South African journal, I'll just read part of what he said in that article. The idea of a judicially enforceable implied limits on the power of constitutional amendment is particularly unacceptable in cases where a constitution explicitly outlines the fundamental principles and subjects such principles to amendment, as is the case in South Africa. In the absence of a clearly defined and enforceable substantive limits, the judicial control of constitutional amendments will lead to a situation where courts effectively arrogate the role of the people and their elected representatives in defining a polity's fundamental values over which there may be a reasonable disagreement. The absence of clearly defined limits also means that every constitutional judge will have his or her own list of what is basic and what is not. The judicial power to define basic social and political values belies the ideal that courts should merely apply settled rules and principles and not discover some vague fundamental values to invalidate the best judgments of the overwhelming majority of the political representative. In the absence of clearly established substantive limits and an explicit jurisdiction to enforce substantive limits on constitutional amendments, the power and responsibility of ensuring compliance with any desirable substantive limits lies beyond the courtroom. Only the democratic process or a revolution could legitimately and effectively stymie any attempt to legitimize undemocratic behavior through constitutional amendments, end of quote. Similar sentiments on infallibility of judges are expressed in an article entitled "The Conundrum of Unconstitutional Constitutional Amendments" by Paul Jen Yap, and he states, "The people may not always be right, for popular sovereignty is not an absolute guarantee of substantive justice, but neither are judges infallible in their moral deliberations. In these circumstances, the judiciary must cede to the expression of popular sovereignty, not merely because the amendment is an unmistakable expression of public will, but because this convergence of interests is undisputable evidence of the triumph of the political process over the intervening institutional and electoral barriers erected by the separation of governmental powers," end of quote. In my view, it is not correct to elevate judges to the status of demigods, and just as it is possible to have a distrustful and rogue parliament, it is also possible to have a rogue and distrustful judiciary, more so bearing in mind that the latter are not elected as the people's representative. I know that as Kenyans, we love to demonize our elected political leaders. We do this all the time, but rarely do we stop to remember we get the leaders we deserve. I am therefore of the persuasion that the contest of what is amendable and what is not should not be left to be a matter of judicial innovation. Judges, just like parliamentarians, cannot assume supremacy over all others, as indeed it is the people who are sovereign. Article 1, Sub-Article 1 of the 2010 Constitution screams out, all sovereign power belongs to the people of Kenya and shall be exercised in accordance with this Constitution. End of quote. The people of Kenya, in the exercise of their constituent power in a referendum, voted for the amendment of the pre-2010 Constitution. In came the 2010 Constitution with provisions on how it can be amended in accordance with this Constitution. On the ultimate expression of the will of people, I find an article by Yaniv Rosnai on constitutional amendments to be telling. And allow me to read this passage. He says, constitutional amendment seems puzzling. The Constitution is the highest positive legal norm. The power to amend the Constitution presupposes the same kind of power as the one to constitute a Constitution. It is a supreme power within the legal system, and as such, it can reach every rule or principle of the legal system. If this power is indeed supreme, how can it limit itself? If it is limited, how can it be supreme? This is the legal equivalent of the paradox of omnipotence. Can an omnipotent entity bind itself? Both positive and negative answers to these questions lead to the conclusion that it is not omnipotent. Moreover, if the amendment power is a kind of constituent power, then it remains unclear why a prior manifestation of that power prevails over the later exercise of a similar power. Quite the reverse, according to the principle, a later norm should prevail over a conflicting earlier norm of the same normative status. Finally, the Constitution, which expresses the people's sovereign power, binds and guides ordinary law, which expresses the Parliament's ordinary power. The common meaning of unconstitutionality is that an ordinary law, inferior to and bound by the Constitution, violates it. How can unconstitutionality refer to an act carrying the same normative status as the Constitution itself? The question posed by Yaniv Rosnai is, the question that he has posed, why a prior manifestation of that power prevails over the latter exercise of a similar power, underscores the people's will to amend the Constitution without a prior manifestation of that power prevailing over the subsequent exercise of a similar power. Suffice to state that in the 2010 constitutions, Kenyans recognize their constitutional right to amend the Constitution as long as this is done in the manner provided in the Constitution. If perchance the framers of our Constitution had intended that there be a limitation on the power of amendment, they would have provided as much. There are no such limitations in Chapter 16 of the Constitution. And at the risk of being repetitive, I reiterate there is no clause in the 2010 Constitution that prohibits amendments, but there is an inbuilt mechanism that provides safeguards, and I'm of the persuasion that the High Court erred in imposing another hurdle on the basis of an implied provision anchored on the spirit or overarching theme of the Constitution. In my view, the High Court erred in invoking the spirit of the Constitution without the need to do so, given the clear and ambiguous language of the 2010 Constitution on amendments. It is also my view, as explained above, that the findings of the High Court were not supported by the context, structure, and history of the Constitution 2010. The upshot of the above analysis is that the appellant's appeal on the non-applicability of the basic structure is for allowing However, this is subject to the majority decision of this court. So much as relates to the issue of the basic structure. The next, I shall then proceed now to look at the role of the President, the role of His Excellency, the President in the BBI process. I think for a start, for me, the beginning point is Article 131(2)(c) of the Constitution, which requires the President to promote and enhance the unity of the nation. And with the noble intention, on 9th of March 2018, His Excellency the President, Uhuru Muigai Kenyatta, held talks with the former Prime Minister Raila Odinga that culminated in what is now commonly referred to as the handshake. The intention of the handshake was to bring to an end the political disharmony, demonstration process, and disgruntlements that arose with the outcome of the presidential elections held in August 2017. The handshake would then become a political tool to calm the nation that was deeply divided and to allow for consensus building. I think the history about the formation of the task force, as well as the formation of the steering committee, were well captured in the introductory part of this judgment that was done by the President of the court. And I will not repeat that, but suffice to state that it is not in dispute that the task force on building bridges to Unity Advisory Task Force was appointed by His Excellency on 24th of May 2018, and subsequently this gave way to the steering committee, and that the process leading up to the formulation of the Constitution of Kenya Amendment Bill 2010, in my view, was largely driven by the executive, as it is difficult to truncate the BBI task force and the BBI steering committee from the submissions of the letter by Honorable Junet Mohammed and Honorable Waweru as promoters of the Constitution of Kenya Amendment Bill 2020. It is clear that one thing led to the other until the culmination of the letter of 18th November 2020 by Honorable Junet Mohammed and Waweru and Honorable Waweri to the IEBC seeking approval of the format to be used in the collection of signatures. Article 256 and 257 of the Constitution provide for amendments by way of a parliamentary initiative and not a popular initiative. The proposals by Honorable Junet and Honorable Waweru would best have been channeled through a parliamentary process, as they were heavily laden with the executive arm. The route of popular initiative was not open to them, as this was not a Wanjiku-driven process. There was an alternative argument that although His Excellency the President Uhuru Kenyatta, was not a promoter of the Constitution of Kenya Amendment Bill, it was contended that nothing stops him from being a promoter of a popular initiative in his own personal capacity, as it may well be possible that a president may find himself in a peculiar position that she does not enjoy the support of Parliament, hence he would be locked out of both the parliamentary as well as the popular initiative. Mr. Kiragu Kimani, Senior Counsel, while urging the appeal on behalf of His Excellency, submitted that the President under Article 38 of the Constitution of Kenya has a right to make political choices just like any other Kenyan, and that the term initiator that was used by the High Court in reference to His Excellency the President was not recognized in the Constitution, and that there was nothing that barred the President from being a promoter of the bill, that the President has a right to campaign for any political party or cause. Further, that Article 12 of the Constitution provides that every citizen is entitled to the rights, privileges, and benefits of citizenship, subject to the limits provided or permitted by this Constitution, end of quote. It was contended that if we were to find that His Excellency the President in his personal capacity cannot use the route of a popular initiative, then this would be tantamount to denying him his rights as a citizen. In my view, the balancing of the rights of a sitting president poses a challenge, as it is difficult to make a demarcation when a president is acting in his personal capacity vis-a-vis his official capacity. Can a president cease to be a president without handing over power during the tenure of his office? In the circumstances of this case, we were told that His Excellency Honorable Uhuru Kenyatta was not the promoter. Indeed, the High Court acknowledged that His Excellency the President was not the promoter, and they coined the term initiator, a term not anywhere in the constitutional amendment process. Be that as it may, the question to be answered is whether His Excellency the President can be a promoter of an amendment bill. In my view, I would liken the situation to that obtaining in the military, where military personnel are often said to be children of a lesser God, to the extent that some of their fundamental rights are limited by virtue of their joining the military. Regrettably, by conduct, there are limitations placed on public officers as to what they can do and what they cannot do. I liken the position of His Excellency the President to that of a judge, where one is a judge 24/7, and it is difficult to say when he or she is not acting in his official capacity. Given the above, it is my humble view that His Excellency the President cannot therefore be a Wanjiku for the purposes of Article 257 of the Constitution, and to this extent I'm in agreement with the High Court findings that His Excellency the President cannot initiate changes to the Constitution through a popular initiative as provided in Article 257. The third item that I will go into is the issue of the legality of the BBI Task Force and the BBI Steering Committee. As to the issue of the legality of the BBI Task Force and the Steering Committee, and as explained above, the Task Force and the Steering Committee were born out of noble intentions of His Excellency the President. Both were ad hoc committees appointed by His Excellency the President for purposes of advising him on the discharge of his constitutional mandate in fostering unity in the nation. The question of illegality of the BBI Task Force had actually come for consideration before Mativo J, who had considered this issue and had come to the conclusion that His Excellency the President acted within his powers under Article 131 and 132 of the Constitution. This was in the case of Third Way Alliance. I've also had the advantage of reading the draft judgment of my sister, Okwengu J.A., and I'm in agreement with the sentiments expressed therein that the BBI Task Force and the BBI Steering Committee were not illegal outfits. On the issue of the presidential immunity, I shall not take much time on this, save to agree with what the High Court said, that when it comes to civil proceedings, the President is not insulated if he does anything or fails to do anything in his own personal capacity. Then there is the issue of the quorum of IEBC. On the question of quorum of IEBC, the appellants and the respondents in support of the appeal challenged the High Court findings that the IEBC was not quorate for purposes of its business, including the verification of signatures in support of the Constitution of Kenya Amendment Bill 2020. For a start, the IEBC is an independent constitutional commission established pursuant to Chapter 15 of the 2010 Constitution. Article 250, Sub-Article 1 sets out the composition of an independent commission. It reads, each commission shall consist of at least 3, but not more than 9 members. On the other hand, Section 5 of the IEBC Act provides that the commission shall consist of a chairperson and 8 other members appointed in accordance with Article 250, Sub-Article 50 of the Constitution and the provision of this Act. What I would like to say as regards this issue, or my finding, is that the IEBC, as currently constituted with 3 members, cannot be said not to be constitutionally compliant. And the question that I ask myself, if with 3 members, the commission is constitutionally compliant, and it can continue to operate because it is constitutionally compliant. In circumstances like those, can one really say that for purposes of carrying out its deliberations, the members of a quorum in a meeting must be 5? In my view, I think the constitutional provisions take precedence, and if the commission, as currently constituted, is constitutionally compliant, it can carry out its mandate with the 3 members of the commission. I think it would be absurd to say that it must have, for it to be correct, there must be 5 members. I've also made comments on the 2 cases of Biwott, as well as the case decided by Mwita, as well as the one that was decided by Okwany. But additionally, it is my considered view that the issue of verification of signatures is not a matter requiring a policy decision. The functions of IEBC are spelled out in Section 4 of the Act, and they are numerous. In my respective view, the verification of signatures is not a matter that arises out of the resolution or decisions made by the commissioners at a meeting of the commission, but one dictated by the operation of the law, as the process of verification of signatures is not a policy decision to require the IEBC to be correct. In my view, it cannot be said that in performing such mundane tasks as the continuous education of voters would require the commission to be correct, more so bearing in mind that the commission has a secretariat that undertakes its day-to-day operations. I am therefore of the considered opinion that the verification of signatures was not null and void for lack of quorum, and neither was it a function that required a policy decision. Then there was a question of the role of IEBC in a popular initiative. In paragraph 733 of the impugned judgment, the High Court found that the IEBC's role include verification of signatures and not mere ascertainment of numbers of registered voters whose signatures accompany the popular initiative bill. It would follow that the IEBC would need some legal or regulatory framework to guide it in its operation. On the other hand, if the IEBC role is the venial administrative task of ascertaining numbers, then perchance no further legal or regulatory framework would be required. The court proceeded to define what verification is, and this is what they said. The only reasonable meaning of the term verify, as used in Article 257(4) of the Constitution, includes both the ascertainment of numbers and confirming the authenticity of the signature submitted. The role of IEBC is spelled out in Article 257 of the Constitution. In the matter before us, we were told that the IEBC carried out verification by removing names that did not have signatures. They also removed names that did not have the national identity cards or passport numbers. They removed duplicated numbers and asked the promoters to depone affidavits, to have affidavits deponing that the signatures were collected with the consent of the parties. I have in this judgment reproduced a format of the collection of signatures that was submitted by Honorable Junet Mohammed and Honorable Waweru to IEBC, and it was approved. And that format captured the following details. One had to include their name, their ID or passport number, their county, their constituency, their county assembly ward, the polling station, their mobile numbers, their email address, and then they also had to sign or to thumbprint. Article 257, Sub-Article 4 did not, in my view, envisage a forensic examination on the authenticity of the signatures, more so bearing in mind that IEBC does not have a repository of signatures. But even if it had, in my view, it would be a Herculean task to undertake. For instance, the verification would require that IEBC obtains non-signatures of those who appended their signatures to the initiative. The non-signatures would then be subjected to forensic investigation by handwriting experts. Given that the IEBC published the list of those said to have supported the initiative, what was so difficult for one to say that they did not append their signatures? In my view, to place near impossible demands on IEBC would, as it were, greatly cripple the operations of IEBC. On the question of continuous voter registration, the High Court found that there had been no evidence that the IEBC had sensitized citizens that there was continuous voter registration. It is this finding that led to Declaration Number 9 in their judgment, wherein the court declared that the Constitution of Kenya Amendment Bill cannot be subjected to a referendum before the IEBC carries out nationwide voter registration exercise. Mr. Morara Omoke, the 76th respondent, urged us inter alia that the IEBC could not conduct a referendum before conducting nationwide voter registration, as this would disenfranchise many voters. The IEBC, on the other hand, argued that it had been continually conducting voter registration at the constituency level. Article 88, Sub-Article 4 requires IEBC to undertake continuous registration of citizens as voters. Suffice to state that this is an ongoing process, and it is upon every Kenyan who attains the age of 18 to register as a voter. It is the same registered voters who vote in an election that also vote in a referendum. Indeed, the 1 million persons who support an initiative are registered voters. Further, there is a distinction between the time and place of an election vis-a-vis the time and place of a referendum in the 2010 Constitution provides for an election cycle. We know that elections are carried out after every 5 years. Not so when it comes to a referendum, as there is no defined time when a referendum is to be held. In my view, the fact that IEBC carries out continuous voter registration, it cannot be said that they fail to carry out nationwide voter registration when we know that the time and place of a referendum, unlike an election, is not known and cannot be defined with specificity. Then on the question of creation of new constitution, as regards the issue of creation of 70 new constituencies, in Declaration Number 14, the High Court held that the Constitution of Kenya Amendment Bill is unconstitutional insofar as it proposed to predetermine the allocation of 70 more constituencies. It held it is unconstitutional for a Constitution of Kenya Amendment Bill to directly allocate and apportion constituencies in contravention of Article 89 of the Constitution. Indeed, that provision was in Clause 10 of the Amendment Bill. Article 89, Sub-Article 1 of the 2010 Constitution provides that there shall be 290 constituencies for the purposes of the election of members of the National Assembly provided in Article 97(1)(a). The respondents opposed to the appeal contested this part of the bill on the basis that it sought to amend Article 89(1) of the 2010 Constitution. Firstly, it is important to say that the High Court held that Article 89, Sub-Article 1 of the 2010 Constitution is not what they were calling an eternity clause, and they said that it is amenable to amendments subject to due process being followed. They stated as much at paragraph 670 of the judgment, I shall not go over it. It is clear that the court recognized, and rightly so in my view, that Article 89(1) of the 2010 Constitution is amenable to amendment. Having so recognized, was it unconstitutional for the Constitution of Kenya Amendment Bill to purport to create 70 more constituencies? In my view, once we appreciate that Wanjiku can seek to amend any provisions of the Constitution as long as the procedure set out in Articles 255 to 259 of the Constitution is adhered to, then the Kenyan people have the right to reduce or increase the number of constituencies to ensure that there is no underrepresentation. They can even vary the mandate of IEBC. Further, the functions of IEBC are spelled out in Section 4 of the Act, include delimitation of constituencies and wards in accordance with this Constitution. Black's Law Dictionary defines delimitation as the act of making a boundary or fixing a limit. Suffice to state that the Constitution of Kenya Amendment Bill 2020 did not seek to make boundaries or fix the limits of a boundary, but increase in the number of constituencies. The allocation of increased constituencies is not, in my view, delimitation. And clearly, the IEBC has no role to play in the creation of constituencies. And the upshot of the above analysis is that the second schedule to the Constitution of Kenya Amendment Bill 2020 in seeking to determine the creation of 70 more constituencies, in my view, not unconstitutional. We shall then look at the IEBC regulatory framework, and I will not go into great details on this, but suffice to state that the Constitution, the IEBC Act, the Elections Act make provision as regards the conduct of a referendum. And it is my considered opinion, and contrary to the findings of the High Court, that there is legislation pursuant to the Constitution, the Independent Electoral and Boundaries Commission Act, and the Elections Act to govern the collection, presentation, and verification of signatures, and a legal framework to govern the conduct of a referendum. Indeed, the High Court appreciated as much when at paragraph 783 of the judgment, they stated as follows, and I quote, "Notwithstanding the absence of an enabling legislation as regards the constitutional expectation, values, principles, and objects, especially those in Article 10 of the Constitution, are met," end of quote. Besides, in the titles Alila and two others versus the Attorney General, the High Court had held, and I quote, "Secondly, I find that the Constitution has already set up a proper legislative framework for holding a referendum." And the court further stated, that is the High Court, further, there are explicit provisions in the Elections Act which govern the conduct of referendum in Kenya, end of quote. In the impugned judgment, the court had endorsed the findings in the Alila decision. At paragraph 603 of the judgment, it stated, "Though we have found that it is necessary to enact Referendum Act, we do not subscribe to the school of thought that absence of legislation implementing a provision of the Constitution renders such a provision inoperative and unenforceable. On that finding, we agree with the decision in titles Alila and two others." And at paragraph 6 of 6, the court stated, "It is, however, our view, and we hold that notwithstanding the absence of an enabling legislation as regards the conduct of referenda, such constitutional process may still be undertaken as long as the constitutional expectation, values, principles, and objects are met," end of quote. In my view, it is surprising that having found so, the High Court proceeded to make a declaration to the effect that A declaration is hereby, this is what they said, a declaration is hereby made that the absence of legislation or legal framework to govern the collection, presentation, and verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed, end of quote. In my view, it is my view that the IEBC existing statutory framework as well as the administrative procedures established therein was sufficient for purposes of carrying out a referendum. However, I am alive to the fact that there is referendum bill, there are two referendum bills that are pending before Parliament. It is my considered opinion that notwithstanding the fact that these bills have not been passed and fully debated by Parliament, it cannot be said that there was no regulatory framework to govern the conduct of a referenda. Consequently, it is my finding that there is legal framework to govern the collection, presentation, and verification of signatures, as well as the conduct of referenda. The other aspect is the issue of whether His Excellency, the President, was served with the petition and the hearing notices. And in my view, I think this is a fairly straightforward matter. There was at no point was the High Court told that shown any return of service or affidavit of service in respect of service upon His Excellency. What Mr. Oluchwer had said is that he had used an email address, and although Mr. Oluchwer had said he sued him in his personal capacity, that address seemed not to have been a personal address. But even notwithstanding that, it was imperative upon the court, once it came to the conclusion that the Attorney General could not appear for the President, to have ascertained at that point in time that His Excellency the President had been served with the hearing notice or with the petition. In my view, His Excellency the President was entitled to equality and freedom from discrimination as per the dictates of Article 27(1) of the Constitution, which provides for equality and freedom from discrimination. And then there is also Article 25(c), which provides for a fair trial as a fundamental right. In my view, the right to be heard is enshrined in the 2010 Constitution, and no one can be deprived of this right. This court has underscored the right to be heard in the decision of Onyango Olo versus the Attorney General when it held that the principle of natural justice applies where ordinary people reasonably expect those making decisions which will affect others to act fairly, and they cannot act fairly and be seen to have acted fairly without giving an opportunity to be heard. A decision in breach of the rules of natural justice is not cured by holding that the decision would otherwise have been right, since if the principle of natural justice is violated, it matters not that the same decision would have been arrived at. Denial of the right to be heard renders any decision made null and void ab initio. In my view, it matters not that His Excellency Honorable Uhuru Muigai Kenyatta is the President of the Republic of Kenya. He is entitled to the protection of the law, as the law protects the weak as well as the strong. It was wrong for the High Court to have proceeded with the hearing and thereafter make adverse findings against His Excellency Honorable Uhuru Kenyatta without ascertaining whether he had been served, either with the petition and or the subsequent hearing notice or hearing notices. With regard to issues raised by Mr. Morara Omoke, whether the bill violated Article 43(1)(a) of the Constitution in view of the COVID-19 pandemic, whether both or either of the houses of Parliament were infirmed from considering the constitutional amendment bill in view of the Chief Justice's advisory opinion for the dissolution of Parliament, and whether the petitioners had made out a case for disclosure and publication of the BBI Steering Committee's financial information. I've had the advantage of reading the lead judgment by Musinga J.A., the President of the Court, on these issues, and I entirely agree with him. I've made a few comments, but in the interest of time, I will not go through those comments. And on the appeal by the Kenya National Union of Nurses, the 15th respondent herein, the gist of their complaint was that whereas their views had initially been included in the BBI task force, the same did not find its way to the Constitution of Kenya Amendment Bill 2020. They supported the appeal and urged us to find that the amendment process was legal and constitutionally sound, and faulted the High Court for finding that the basic structure doctrine applied in Kenya. As stated above, the 15th respondent's grievance is that their views, whereas their views of having an independent commission were initially captured in the BBI task force, these views were subsequently omitted. In my view, this is a fairly straightforward issue. If the 15th respondent would like an amendment of the 2010 Constitution to have itself included as an independent commission, they can take advantage of the provisions of Article 257 of the Constitution. They cannot ride on an initiative of another and complain that their views have been left out. In any event, the fact that their views were contained in the BBI task force did not create any legitimate expectation on their part. I shall say no more on this issue, save to state that the appeal is devoid of merit and it is accordingly dismissed. Those are my views. Thank you.
Thank you, my sister, Justice Sichale. We will now have my brother, the Honorable Mr. Justice Gatembu, summarize his judgment.
Thank you. Thank you very much, President. I think at the conclusion of the argument last time we sat here, you told us that when we retire, we can consider your submissions and other material. Now, I think it is my turn to say that when you retire, you can read our judgments in full. So I'll give you just a short synopsis of what I have said in my judgment. So this is what I have said. In this judgment, I only address some of the issues arising from